All right, looks like we are live. I'm George, co-founder of SoloSuit. Thanks for coming to our webinar. We're going to go over the basics on how to resolve a debt lawsuit tonight. If you are already a SoloSuit customer, or if you're just finding out about SoloSuit for the first time now, glad that you are here. We're going to get you what you need. I'm going to go over some of the basics here in just the first few minutes, and then here in just a little bit, we're going to take your questions and hopefully give you some answers. If you have questions, you can put them into the YouTube chat. Jaren, hello, good to see you. Our team member Hannah is also going to be responding to the chat, and then I'll go ahead and respond to some questions live as well. Before we get started, I just want to give a disclaimer saying that I am not an attorney. I'm not your attorney. SoloSuit isn't a law firm, and this isn't legal advice. All right, no, this replaces the consultation of a lawyer, and those are some things that I need to say because of regulations on the provision of legal services. All right, so jumping into things, how to resolve a debt lawsuit. First, we got some good news, which is that people who use SoloSuit enjoy about a 70% win rate. Without SoloSuit, people barely win, no more than 10% of the time. Usually, they can't even manage to respond to a debt lawsuit when they're sued for debt. With SoloSuit, we get about a 70% win rate. So we increase the win rate by 7x. What that means is your case might settle. So you might respond to a debt lawsuit, then you get a settlement agreement where you might get thousands of dollars hacked off your debt, right? Let's say you're being sued for $10,000, and then you settle it for $4,000. That's a big win, and we consider that a win. Another thing that might happen is you might get your case dismissed. So you might respond to the lawsuit, and then the collector might find out, oh, I'm suing the wrong person. I'm just going to dismiss this case, remove it from court. That's a huge win. It means you don't end up paying anything in that case. And then some of the time, the case is ongoing, right? So we protect you from a default judgment. The case progresses normally, which means you might have to show up in court, and you might also have to respond to some additional documents. But it buys you time to file for bankruptcy if you want to. Also, just make sure you didn't lose by default judgment, and protects you from that bad loss. And it gives you a better chance in court. All right. As you're finding out, debt sharks oftentimes exploit people. They use the system to exploit them. We take the real-life example of Raquel. She's down on her luck, gets sued for a $1,000 debt. She wants to respond to the debt lawsuit. First she goes to an attorney. She finds out an attorney wants like $3,000 just to respond, just to get started. She doesn't have money for that, of course. So then she tries going to like free legal aid or pro bono clinic, but she finds out, they take 3 weeks just to get started, and she doesn't have time for that. So she tries doing it herself. She tries the DIY solution, but then she finds out, even after she's generated the answer document, she needs the mailing address for the court. She needs to calculate the filing fee. She probably needs a printer, and she needs to use snail mail, which she hasn't done in like 20 years. She has to go into the USPS and mail the document in, or she has to take time off work, go down to the court herself. And she only has like 21 days to respond, so unfortunately she misses this 21-day deadline, and then practically overnight, $1,000 debt balloons into like a $3,600 judgment. That's bad news for Raquel. So we don't want that to happen to you, and we're going to show you how to avoid that situation here with SoloSuit. All right, so we make it easy to respond to a debt lawsuit. You can use us to answer the lawsuit, and then if it's a credit card debt with a arbitration clause, you can use our documents to compel arbitration. And then if you're like most of our people, you'll ultimately want to settle the debt for less and save hopefully thousands of dollars by settling and getting it all nice and wrapped up, nice and tidy like. All right. So those are kind of basic idea, right? So if you want to answer the lawsuit, basically just go to solosuit.com/debt-answer, or just click the reply to a lawsuit button. And then we'll ask you some questions, you give us some answers, we use the answers to generate the document. You can pay us to have an attorney review the document and to file it for you in court. We make it real easy, right? It could be done in 15 minutes. You can use our motion to compel arbitration. You have to file that one on your own, unfortunately. You can use that to force the lawsuit into arbitration. Then you can use our new tool, Solo Settle, to settle the debt. You can use it to make an offer to the collector. And you can engage in a negotiation back and forth with the collector, and then we'll protect your financial information and help you get the collector paid. All right, so those are the basics. Let's jump into some questions. Looks like we got some good questions. And getting into this, I want you all to know that there's hope. No matter how dire your situation is. About 10 million people get sued for debt every year in the U.S. So you're not alone, and a lot of them bounce back. Right? I think for a lot of people, being sued for debt is just a stepping stone. It's a thing that you will pass through, and things will be better on the other side once you get this all resolved. Right? It's one step. We're just responding to it. Fighting it is one step to greater financial freedom, which is coming up for you. All right, let's take a look. We got Alex. I got sued, and they served my grandmother at my old address. I'm a resident in a different state. Is there jurisdiction? Great. Good question. So, for a lawsuit to be valid, just like on its face, somebody needs standing. So that means there has to be a real harm usually caused in debt lawsuits. It's the creditor hasn't been paid or the plaintiff hasn't been paid the debt. There has to be jurisdiction of venue. So you have to be sued in the right court. So you're saying that your grandmother at your old address. I'm a resident in a different state. So I think you're saying you used to live with your grandmother in a different state, and they served you by giving the documents to your grandmother in that state. Now you live in a different state. Is there jurisdiction? That's a tricky question. Ultimately, one, you have to kind of research a little bit more on yourself. It really depends on the facts of the situation. You might want to talk to a lawyer a little bit more about that one. But the general idea is, these lawsuits can be brought in different states. They can sue you, right? So maybe, arguably, you could be sued where you live in your current address, even if the debt was opened in a different state, a different address. You could also be sued where you opened up the account. In my experience, usually you're most likely to be sued in the state where you opened up the account. That's where the debt originated. There might be a good reason for the lawsuit to go on there. It's a big pain though, because you might have to travel back to that state to deal with the lawsuit. But the main thing is that you can bring up a defense saying that the lawsuit is in the wrong venue. If you don't see how to do it, by clicking the right buttons on our website, you can just bring that up with our support person once you file an answer, and once you generate an answer, and we can make sure that gets taken care of and in your answer for you. Generally speaking, when you receive a complaint and summons, you got to file an answer document in court, and the answer document is responding to the complaint. So usually you're going to respond to all the allegations in the complaint. An attorney is very likely to just deny all the allegations in the complaint. And then you have to bring your affirmative defenses. A lot of free forms online, court forms don't really help you bring affirmative defenses. And they're really important because you can only bring them up at this point in time in the answer document. If you don't bring them up now, you waive the right to bring them up later. So this improper venue is something that you want to bring up in the answer document. And it really doesn't hurt to bring it up. Usually a lawyer will make all of these defenses, just a blanket series of defenses, because if they don't bring them up now, they can't bring them up later. And it's up to the plaintiff to prove that their case is valid. It's not up to you to prove that you're not liable. It's up to them to prove that you are liable. So you can certainly bring that up in the answer document, and the lawyer would certainly, if there's really any question, they're going to bring that and then you can find out if it's the proper venue or not by contesting it in the lawsuit. All right. So, Jules, what's up? Good to see you. Glad you're here. Carolina, how often do they sue? Sounds like you're asking. It'd be helpful if you said who you're talking about, like what creditor you're talking about. Lawsuits are pretty common, so just like taking the biggest collector in the U.S., which is Midland Funding, owned by Encore Capital. They do a lot of collections during the year, and I think I recall about 25% or more of their revenue coming from lawsuits. I think it might have been like 50% or more of their revenue being collected from lawsuits. So that kind of suggests that maybe they sue people about 50% of the time, 50% of the time. But being sued is pretty common. Most collectors, not all, kind of consider it like a last resort, so they'll try to collect first, just like by making a phone call or sending a letter. If you don't respond to that, they might send you a lawsuit, and they'll try to collect by the lawsuit. They usually use it as a last resort because it's more expensive for them, and they have to share some of their income with the law firm, which usually they don't want to do. Okay. Again, about another way to look at it, 70 million people have debt in collections every year. Only about 10 million. Some estimates are as low as 4 million get sued for debt every year. So that's 10 divided by 70. So that's like less than 10%, or a little bit more than 10% are getting sued. Okay. All right, Brian, I used your paid answer letter. Very simple. Well worth the price. Case still pending. Was wondering if SoloSuit has a service to stop garnishments. Great. Brian, glad you used the answer service. Glad it was great. Glad we protected you from that default judgment. That's great. Case is still pending. That's pretty common, right? Oftentimes cases are pending after the answer document for a while. Usually I wouldn't expect to see any action from the plaintiff on the account for at least a month. Most of our cases get some kind of a resolution on average in about 4 to 6 months. That's an average. The range is pretty broad, right? Sometimes things can take years to wrap up, even in these pretty simple lawsuits. Brian, I guess I wonder if you have an ongoing garnishment. If you have an ongoing garnishment, no, we don't really have anything to help you with that. You can always try to make a settlement offer on garnishments, but unclear if someone's really going to accept that if they're currently garnishing your wages. But you can try to say, hey, I could give you $1,000 up front right now to settle this account. When the face value is like $1,500, I could pay you $1,000 right now just to wrap all this up. Or maybe they'd take something like that if they're currently garnishing you. Main way to stop garnishment is to respond to the lawsuit when you get the complaint and summons, and then try to settle it in the lawsuit so that they don't get a judgment against you and so they don't garnish your wages. Part of the big pain about garnishment is that once your wages are being garnished, that means that you lost the lawsuit, and that means that post-judgment interest has been applied to your debt. Post-judgment interest can be quite significant sometimes, maybe like as high as 10%. So that can be pretty problematic. And then if you've received a writ of garnishment, but they aren't yet garnishing your wages, you can file a motion to set aside judgment, which requests that the judge give you a second chance to file an answer because you never did file an answer at first. And that can be a good option. You can email us at support@SoloSuit. You'll get our answer document, and then you can use our motion to set aside judgment. You have to fill it out yourself. We can get those documents filed for you, even if they are at the point where they're filing to garnish your wages but aren't yet garnishing your wages. Okay. Rika, how do you get an identity theft case dismissed at a trial setting conference? Okay. So Rika, assuming that you are a victim of identity theft and that you're being sued for a debt that isn't yours as a result of identity theft, you definitely shouldn't lose this case, right? So you just want to bring all the documentation that you can, proving that you are a victim of identity theft if you have letters from government agency, or if you've made like complaints or filings with government agencies alleging that you've been a victim of identity theft, or if you have some kind of a statement from a bank or something acknowledging that you are a victim of identity theft. Bring those documents. The key thing to remember here is that it's up to the plaintiff in this trial. It's up to the plaintiff, the person suing you, to prove that you owe the debt. It's not up to you to prove that you don't owe the debt. It's up to them to prove that you do owe the debt. And oftentimes they can't do this, especially if there's a case of identity theft. They aren't going to be able to prove that you are the one that actually owes the debt. Maybe you can request something like a signature, like request to see the signature on the credit card contract. There usually isn't a signature, and therefore, maybe they can't prove that it's you. Those are some thoughts that come to mind on that. Hannah, the thought occurs to me, I'm not sure if we have any articles on identity theft in particular. This is a pretty common thing with our customers. I'd love to point you to an article on our blog that covers that more in depth. I don't know if we have one yet. We'll write one. But that's the general idea. Just make sure you have all of your documentation. Bring it to court. Make sure you show up at court. Don't miss the deadline for the hearing. Show up at the hearing. Look nice. Be prepared. Just make your case that the plaintiff cannot prove that it's you because it was not you that took out the debt. All right. Let's see. Rika, I have a little info about this credit card account, so how do I prove it's not mine? That's a good question. Again, you don't have to prove that it's not yours. They have to prove that it is yours. So it's up to them to prove that it is yours. Trying to think what attorneys will oftentimes say in this case. I think the key thing might be just simply proving that your identity was stolen in some way. Maybe you can look up the history for your name or your email account to see if you were part of any data breaches. Some websites will search to see if you were subject to any data breaches, like maybe you were subject to the Experian data breach, and then maybe someone got your information and they used that to open up your account, open up this fake account. Maybe you could do something like that. Etc. Those are some ideas that are coming to mind here. Jules, if I have been sued and would like to make an offer for the debt settlement, should I contact the lawyer or the debt collector agency to make an offer for debt settlement? Good question, Jules. Usually what you want to do, what most people do, is they contact the lawyer, not the collection agency, right? So on the lawsuit, you'll have on the complaint, it'll show the plaintiff. It'll also show the law firm. The law firm is probably going to be in the top left corner, like the heading or the letterhead of the document, or it might be on the signature, right? So the law firm will usually sign the complaint. The plaintiff will be in the caption, usually on the left side. The plaintiff, like a common situation, the plaintiff might be like Discover Bank, and then the law firm will be like Blitt and Gaines. And who you want to talk to is Blitt and Gaines, right? So you want to talk to the law firm, you don't want to talk to the collection agency or the original creditor. They've hired the lawyer to settle this debt for them. So you can call the lawyer, you can call the law firm. A lot of these law firms have people on the phones, answering the phones all the time. You'll get one of those people. You can also try to track down an email, send an email directly to the lawyer. You can also send a paper document. Most of these law firms and collectors are set up to receive phone calls. You can also use Solo Settle to settle the debt for you. You can make an offer through Solo Settle. You just tell us how much you can pay within 90 days to get the debt settled. and then we'll relay that offer to the collector for you. So that's a good way to go as well if you don't want to do it yourself. Mitch, I've been sent a scheduled docket for next week. I've already answered the lawsuit with your services. Should I settle or compel arbitration next? Good question, Mitch. Okay. So you got a schedule. I guess one of my questions is there a hearing scheduled? If there's a hearing scheduled, we definitely want to make sure you show up at that hearing. Oftentimes lawyers and collectors want to settle at the hearing, right? So if you show up, they show up, the judge will ask at the beginning of the hearing, have you guys attempted to settle yet? If not, then leave the courtroom and then go try to make a settlement in the hallway or something like that. And sometimes they will settle just like that in the hall or in a meeting room or something like that of court. As far as if the case is ongoing, should you compel arbitration or settle first? I wish we had more data. I wish I could tell you definitively this is what the data says here. We don't on this. A lot of people file a motion to compel arbitration and then they're able to settle after that. Generally speaking, that's the route that we've recommended, is you file a motion to compel arbitration if there's an arbitration clause. And then, they might dismiss the case after that, or you can proceed. If they proceed, they have to probably select an arbiter and go through with arbitration. But usually the plaintiff has to pay for arbitration, so they might just get the case dismissed out after that. But if you have some money to settle, if you could pay 60% of the total amount of the debt within the next month or within the next 90 days, then you can go forward with that. It'll probably be the easier option. It'll be more straightforward to wrap things up. You get a nice tidy resolution, right? Even if they do dismiss the case, they might not dismiss it with prejudice, meaning they could sue you again for the lawsuit, for the debt. And even if they lose the lawsuit, they can still try to collect from you outside of court in some cases. So settlement gives you the most tidy resolution to the lawsuit. If it were me, I would probably file for arbitration, and then I would send an offer to settle as well. That's what I would do. A lot of collectors tell us that they think, when we talk to collectors, which we do from time to time, they tell us that the arbitration product is problematic for them. It just makes their life worse and increases lawyer fees and stuff. I'm not sure if I necessarily believe that. I haven't seen the data around it, but that's kind of what they say. They say they prefer people just to settle with them. But honestly, at the end of the day, collectors would prefer if you just paid the total amount of the debt plus all of the interest and attorney's fees and everything else, right? So those are some thoughts on that. Rika, I made an FTC report and a police report. Great. Definitely bring those documents to the court. If you have an FTC statement saying that they agree that your identity was stolen, that'd be great. If you filed those many years ago, that'd also be a good indicator that you are sincere that your identity was stolen. You're just saying that to avoid a judgment in the lawsuit. Liliana, hi, I got served February 18th. I sent out and used you guys to answer the summons. I waited to get a response, and I got a letter from Citibank, the lawyer, to give her a call so we can settle. I never, looks like a little typo here. I never copied out to. I'm not sure what you meant there. So you got served on February 18th. Used this to respond to the lawsuit. You got a letter from Citibank asking you to give her a call. Okay, so it sounds like you got sued, you responded, they wanted to settle with you, right? They're probably asking you to give them a call so they could talk about a settlement solution with you. For me, I'd probably call them at this point in time. You've protected yourself, you've shown them you know what you're doing, you filed an answer in court, you've protected your rights. You can get on the phone, have a call with them. You should check out, if you search our website or search SoloSuit on Google for a map of phone calling laws, Hannah's made an awesome map that shows which states you actually need the consent of the other party to record a phone call. It turns out most states you actually don't. It turns out most states you can just record a phone call just with your own consent. That's it. So I'd record that phone call if you do call the law firm, depending on your state, and then you can see what they have for you to make an offer. They're probably most common offer we see from law firms is about 80%. That's the most common first offer. Certainly we see the most common settlement rate right now on solo settles for 60%. It's the most common settlement rate is about 60%. So you can certainly try to get something around there on the phone. Okay, Liliana, settle. I want to send out the motion for arbitration. Can I still do that? Generally speaking, you can file a motion to compel arbitration at pretty much any time in the lawsuit. Most commonly, it's done like right after filing an answer. That's when most people are going to do that. And it doesn't prohibit you from settling in any way. Okay. What happens? We got Kersey. What happens after solo suit sends the court the answer? What happens next? Okay. So let's say you get complaint summons and you get served a complaint summons. You respond by filing an answer document in court. What happens after that is solo suit. If you paid solo suit to file for you, we will send the document to the court. We'll give you the tracking numbers. Then you have to make sure that it gets there and that it gets filed once they receive it. And in some cases, we e-file. Depending on the state, we actually e-file, which is nice because that's so quick. Then what happens next is one of three things usually. So you can make an offer to settle, or they'll contact you to settle. You can use solo settle to make an offer to settle. It's a great way to do it. Just takes a few minutes on our website. The case might get dismissed, so the plaintiff might think, oh man, crap, we actually can't prove that this person owes the debt. I didn't think they were going to answer. You threw a major wrench in their machine by filing an answer, and now they realize they don't have a case, so they might just dismiss the case. So they might file a motion to dismiss. The judge will say okay, and then the case is dismissed. And then sometimes the case will be ongoing, right? That's probably the most, I don't know if it is like the most common, but in some way, the case is ongoing until one of those two things happen, or until like the next thing happens. So if it's ongoing, the plaintiff might, the person that's suing you might file a motion for summary judgment, meaning that they're asking the judge to make sure that they win outright immediately. That's like an outcome. They might file for discovery. Okay. I'm going to try to cruise through here because I do have to wrap up pretty close to like 5:30 this time. If I don't get to your question, feel free to jump on next week. We usually do these webinars every Wednesday at 5 p.m. Mountain Time right now. I'm in Mountain Time. I'm in Utah. So I've got to hop off here in just a couple minutes here. So I'm going to try to cruise through here. Okay. KW, is it legal for a third party to sue you? Example, debt with department store, account closed and charged off and bought it from her third party now suing for the debt. Yes, it's definitely legal. It's very common. It's probably the most common type of lawsuit. So usually it is a third party debt buyer that's bringing these lawsuits, right? So like you have a Comenity credit card from like Victoria's Secret or something like that, and then they take that debt, they sell it to somebody else, like Midland Funding, and then Midland Funding sues you for the debt. Very common. There's like some legislation passed, I think in like 90s, that kind of allowed debt buying to become more common. It's become much more a larger market over the last few decades. Can you file a motion to compel after summary judgment is filed? Yeah. Yep. Generally speaking, yes. Again, I'm not certain. It kind of depends. It's nuanced depending on where you are. Generally speaking, you can file that motion. Yes. You also, if there's a motion to summary judgment, you'll want to file a counter motion. Okay. Sarah, husband is being sued. Let's see. Husband is being sued for a 3-day hospital stay in which he objected to the entire time. It actually caused him a great deal of distress with no answers found. Can these Grieves help our case? Not sure exactly what it means. He objected, but he's being sued for medical bills around a 3-day hospital. It does seem like collectors behave differently depending on what type of the debt, what type the debt is. Medical debt's being forgiven much more frequently these days. Right? A lot of groups are trying to get medical debt forgiven. But if you're at this stage, it's probably not going to be forgiven just as part of these big group forgiveness programs. You can certainly call in and explain to them your case. Like if your husband has ongoing hardship, like if he has a medical illness or something like that, you can explain that to him and say, hey, this is why I can't pay this debt, etc. So you can, those grievances can help. They don't go in the answer, so the answer isn't like a place to tell your story exactly like this. You can bring it up in settlement. Scott, does the amount of debt being claimed affect the direction we should take? Is a suit for $3,000 worth arbitrating? Yeah, the amount of the debt of the lawsuit does affect things. Like if it's a bigger debt, it's more likely that the law firm is going to continue with the lawsuit to try to collect. We have people try to arbitrate for a $3,000 debt all the time. Yeah, because it doesn't cost you very much to arbitrate. Usually the credit card agreements are framed up so that the plaintiff has to pay for the arbitration. So the key is that it probably wouldn't be worth their time to arbitrate for a $3,000 debt, so they might drop the case. Helen Garcia, I'm being sued for a debt that does not belong to me. Items purchased using my information. I never lived at the address items were shipped. They have nothing with my signature or proof. Okay, great. Yep, just bring that up and file it. Make sure your answer is filed. Make sure you file your answer. We have like some questions where you'll say like I never received the goods purchased. They're suing the wrong person. You can click those buttons and we'll put that in your answer for you. And then just make sure you bring that up in your lawsuit. If you can have written documentation around this, that would be best. All right. Takesha, I got a letter for final judgment. Well, an email from the law firm I used for the first time for that summons to contact the company who filed. We already made an offer, but I didn't realize my auto payments. Okay. Not exactly sure what you're saying there. It sounds like you got a final judgment. Sometimes the collector will send you a proposed order from the court. It's different from an actual order. It's going to be kind of confusing. An actual order, like an actual final judgment, will usually have a stamp or like a certificate or a signature from the judge showing that it's the real thing. Sometimes collectors will send you like a proposed order, kind of as an intimidation tactic. So you just want to make sure you actually lost the case. Then you can appeal. If you don't file an answer, you can file a motion to set aside judgment and then file an answer. All right, last question. Do you have experience with Synchrony Bank? Yes, we do. Very common plaintiff, very common original creditor for our lawsuits. Right? They back the store cards. Oftentimes the store cards have really high interest, and those are what's leading to these debt lawsuits. So yeah, Synchrony Bank, very common. We respond to them all the time, for sure. All right, folks. Just one more time. Again, this is not legal advice. I'm not an attorney, not your attorney. There's no attorney-client privilege between us or anything like that, or relationship. Good chatting with you all. I sincerely hope that you win your case. Hope that solo suit can help you out. I believe in all of you. I believe all of you are going to overcome this, and that things will be better after this lawsuit's resolved. Glad we could help you out. If we haven't answered your question, you can come back next week, or you can send us an email at support@solosuit.com, or you can check out our great blog